9th Sir, 2024, and we accept all plausible allegations as true. Ashcroft v. Iqbal, 556 U.S. 662, 678, 2009. 3. Section 230 of the Communications Decency Act commands that N.O. provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. 47 U.S.C. Section 230, c. 1. Meta argued below that plaintiff's claims could be dismissed under that provision. Because the district court dismissed plaintiff's claims as untimely, it did not reach the Section 230 issue, but Meta renews its Section 230 arguments on appeal and asserts that the district court can be affirmed on the ground that Section 230 bars plaintiff's claims. We agree. Capital A. First, we consider whether Section 230 applies under California's choice of law rules. Generally, federal courts sitting in diversity apply the law of the forum state, including the forum state's choice of law rules. See Kasserer v. Tissenbornemisse collection found. 596 U.S. 107, 115, 2022. Discussing Claxon Company v. Stentor-Ellick, MFG Company, 313 U.S. 487, 496, 1941. California, the forum state, presumptively applies its own rules of decision. Chen v. L.A., Truck CDRs, LLC, 7 Calories 5th 862, 867, 2019. Plaintiffs argue that the rules of decision of Myanmar apply to some questions at issue. They contend that the rules of decision of California and Myanmar conflict when it comes to immunity for interactive computer service providers. Assuming California's choice of law rules could demand application of Myanmar's rules of decision rather than Section 230. 2. We conclude that plaintiffs failed to carry their burden to show that foreign law applies. See Wash, Mood, Bank v. Superior Court. 24 Calories 4th 906, 921, 2001. California uses the governmental interest test to determine what jurisdiction's rules of decision should apply to a given dispute. See Generally Reich v. Purcell, 67 Calories 2D 551, 1967. This test entails 3 steps. First, we determine whether the rules of decision of the potentially affected jurisdictions differ regarding the issue. See Chen, 7 Calories 5th at 867-68. Second, if the rules of decision differ, we consider the interest of each jurisdiction to decide whether a true conflict exists. To do so, we determine the application of each jurisdiction's laws under the circumstances of the particular case. Scott v. Ford Motor Company, 224 Calories. App 4th 1492, 1503, 2014. Accord Bernhard v. Harris Club, 16 Calories, 3D 313, 320, 1976. Abrogated on other grounds by statute in Cal 104, Code Section 1714, 2012. And we look to the policies animating each jurisdiction's interest in having its law applied. See Offshore Rental Company v. Condor Oil Company, 22 Calories 3D 157, 163, 1978. After all, although 2 jurisdictions may have different laws, there is still no problem in choosing the applicable rule of law where only one of the jurisdictions has an interest in having its law applied. Chen v. L.A., Truck CDRs, LLC, 42 Calories, App, 5th 488, 496, 2019 quotation omitted. And because it is a serious matter to assert a conflict between the interests of the forum and a foreign state, a foreign jurisdiction's interest must be real rather than hypothetical. Citation omitted. Third, if a true conflict exists, we compare the nature and strength of the interest of each jurisdiction to determine which state's interest would be more impaired if its law were not applied. At 495. Quotation omitted. Plaintiff's choice of law argument fails at step 2. The United States' interest in applying Section 230 is clear. 3. Imposing liability on Meta for its actions as a publisher would frustrate Section 230's purpose of promoting the continued development of the Internet and other interactive computer services. 47 U.S.C. Section 230, b. 1. Plaintiffs do not dispute that, so the question is whether Myanmar has a legitimate interest in this dispute. Plaintiffs argue that Myanmar has a significant interest in protecting people within its borders from harm, but the issue here is a question of immunity. Whether American courts can treat a party as the speaker or publisher of certain third-party content. Fair House Council of San Fernando Valley v. Roommates.com, LLC, 521F, 3D 1157, 1162-63, 9th Sir 2008. And Bong, providing immunity for actions that cause harm necessarily implicates the ability of the individuals to prevent or reduce that harm, and to seek redress for any harm suffered. Plaintiffs rely on their foreign law expert, who states that he law on liability of Internet companies in Myanmar is governed by three sources: the Common Law of Torts, the Electronic Transactions Law of 2004, and the Telecommunications Act of 2013. No case law supports the contention that courts in Myanmar would find tort liability for social media companies under these circumstances. Plaintiff's expert conceded that he could find no case in Myanmar concerning a social media company, and the expert report notes that there has been no codification of tort law in Myanmar, and indeed no statutory intervention at all in tort law. Likewise, neither Myanmar statute plaintiff's cite establishes Myanmar's interest in holding social media companies liable in tort for their actions as publishers. The Electronic Transactions Law of 2004 merely provide for validity of electronic signatures and regulate the storage of electronic data, and the Telecommunications Act of 2013 is directed at regulating blackmailing, bullying, making wrongful restraint on, defaming, disturbing, exerting undue influence on or threatening a person using a telecommunication network. Both statutes extend liability to those who abet commission of an offense, but do not address the liability of social media companies as publishers, so neither statute establishes Myanmar's interest. At bottom, Myanmar's interest in protecting its citizens from harmful attacks and misinformation on Facebook, while real, is insufficiently incorporated into the positive law of the country. Myanmar's interest therefore does not predominate. For these reasons, even if we could or should consider Myanmar law, Section 230 applies. Capital B. Section 230 immunizes from liability. 1. A provider or user of an interactive computer service. 2. Whom a plaintiff seeks to treat, under a state law cause of action, as a publisher or speaker. 3. Of information provided by another information content provider. Barnes v. Yahoo, Incorporated, 570 F. 3D 1096, 1100-01, 9th Sir 2009. The parties agree that Meta was the provider of an interactive computer service, so we consider the other two steps of the Barnes test and conclude that, under this circuit's case law, Section 230 immunizes Meta from plaintiff's claims. 1. The second step of the Barnes test asks whether a claim would treat a defendant as the speaker or publisher of third-party content. We consider whether a cause of action seeks to plead around Section 230's strictures. Est of Bride X. Rel. Bride v. YOLO Tex, Incorporated, 112 F. 4th 1168, 1176, 9th Sir 2024. We have been wary of the artful skirting of Section 230 immunity. Kimsey v. Yelp, Incorporated, 836 F. 3D 1263, 1266, 9th Sir 2016, and creative attempt, to plead around it. Lemon v. Snap, Incorporated, 995 F. 3D 1085, 1094, 9th Sir 2021. Accordingly, it is not the name of the cause of action that matters but the duty that the plaintiff alleges the defendant violated. Barnes 500, 70 F3, D at 1101-02, including what the claimed duty requires the defendant to do. Calise v. Meta Platforms, Incorporated, 103 F. 4th 732, 742, 9th Sir 2024. So if a claim turns on a defendant's status as a publisher or conduct of publishing including reviewing, editing, and deciding whether to publish or to withdraw from publication third-party content, it is barred under Section 230. Barnes, 570 F. 3D at 1102. We have also held that Section 230 bars products liability claims that attempt to hold a defendant responsible for user speech or the decision to publish it. Est of Bride, 112 F. Fourth at 1180. Plaintiffs characterize Meta's duty as one of product design, that Meta should not have built Facebook in a way that boosted incitements to violence. Still, the alleged defects relate to Facebook's core design as a publishing platform, particularly how Facebook promotes